So once you file for trademark protection, one of the first things you're going to get is not a bill from the attorney and not a notice that your trademark has been examined, but a bunch of solicitation letters from foreign firms offering to publish your trademark application or do something along those lines. And for their wonderful services, they only want $2,000 or $3,000. So let's look at a couple of these and see whether they're a real value or whether they're a scam. So when you file a trademark application, the trademark application becomes public record. Anyone can look and see the name that you filed for and the name of the applicant. So there are a lot of companies, particularly overseas, that will send you out solicitation letters like these. Let's look at a couple of these in more depth to see whether it's really worth the money that they're asking for. So I've got one right here from a company that calls itself Swift or Whip, something like that. Anyway, they want $2,738 for, looks like a registration of an international trademark. So, wow, are they giving you an international trademark for $2,700? Is it good across the entire planet? I mean, is it good in Mars, maybe the moon too? I mean, international trademark, that sounds pretty heady. Oh, there isn't such a thing as an international trademark. You need to get a trademark in each country, or in cases like the European Union, each collection of countries that will authorize a trademark to be granted there. Okay, so let's see what they're really selling here. We offer to include your trademark in our private international service and trademark directory. Okay, so it looks like you're not getting an international trademark, you're getting publication in an international trademark directory on the internet. Well, last I checked the United States Patent and Trademark Office, once you apply for trademark protection or once you're granted a trademark, your either trademark application or your registered trademark is already on their database. So I don't really see what these guys have to offer that isn't already happening. Let's look at the terms and conditions on the back. Maybe, let's give them a shot. Maybe they've got something to offer here. First sentence. The patent application has been published in the European Patent Reports, which are edited by the European Patent Bulletin. Okay, I'm sorry, you guys are losing me here. This is a registration of international trademarks, and yet you're saying that the basis of the offer is the patent application. Don't you know the difference? I think this is a ripoff. I'm not going to give them my money. Sorry, guys. Okay, one down, one to go. Let's hope these people offer something better. These people want $2,327. Oh, and they put a little note here. For some time, companies WIPT, CTDP, ODM, RIPT, WOIP, making offers, not have been making offers, but making offers to register trademarks. These are insignificant for our trademark services and in no connection to WDPT. Okay, all right, so they're instantly trying to distance themselves from these other horrible scammer companies. All right, let's see if these guys have anything better to offer. I don't know what to say here. I can barely read this English. This form is solely the offer of the concluding of the contract being the year registration of your international trademark application in our internet database. Well, there was no international trademark application. This was a U.S. application. All right, let's look at the fine print, see if we get any more faith in these people. Okay, provider, that's these guys, shall enable applicant the access to the database. Well, I just got access to your database by going on Google. I don't think it's worth $2,000 whatever dollars to let an applicant get access to something that you can get on very easily through Google. Okay, a little further down. Oh my goodness. Provider, that's these guys. They'll be entitled to suspend registration. So you give them your $2,000 and change, and they can cut off your registration if they have justified doubts about the fact whether applicant disposes with all necessary rights, especially copyright or trademark rights, necessary to their publication till, not until, but till, the moment of the justified proving of applicant's rights to provider by applicant. I graduated from law school in 1985. I've seen an awful lot of legalized gibberish come across my office, but In terms of just complete butchering of the English language, you guys are without peer. I mean, this is, you get an A+ for turning what should be a very simple offer into something that nobody can possibly comprehend.